Peace, love, and law to everybody watching. I am reading from Suits and Chancery by Henry Gibson. I am in chapter 4. I'm just going to start reading on notice and its effect. And this is perfect topic because I am currently sending out notices of cease and desist to public officials to stop those injections that they're giving out. So people ask me, are you sure these notices have any effect? I mean, so what if we send notices to the government? They don't even listen to us. What does it matter? Well, I hope this chapter right here can help put some, I would say, substance to that. So I am going to start. Again, this is chapter 4, notices, Lis Pendens, and Estoppel, Acquiescence, Negligence, Laches, Waivers, and Consent. So we're going to start. It looks like it has 6 sections, and we're going to start here. It's section 65. A notice and its effect. No one can transfer to another a greater right to a thing than he himself possesses, and no one can, in reason and conscience, expect to acquire a greater right than the vendor could rightfully sell. So he who buys with notice of another's right is bound in good conscience to hold what he buys subject to those rights, for otherwise he would be taking advantage of his own wrong and would be enriching himself at another's expense, neither of which acts is permitted by a court of conscience. And footnote number 2, as you can see right here, says the assignee is entitled to the rights of the assignor. So if you assign something to someone, you gotta give them the rights. They're entitled to it so that they can perform on the assignment. It makes a lot of sense. Going back here, but the court imputing to the purchaser an intention to do the honest thing will presume that he made the purchase with the intention of holding the property in subordination to those rights of which he had notice at the time of his purchase. To presume otherwise would be to presume the purchaser was acting in bad faith and was intending to perpetuate a fraud on the person of whose right he had notice. So this is talking about purchases. So when and it's also anything in the commercial realm or in the public right now, these transactions, we're dealing with purchases, payments, conveyance, but they're all just purchases basically, because it's when you're purchasing something, well, you give them paper money, right? They are acquiring the same rights. When you give them that paper money and they receive it, they accept it, they now have the same rights you had when you had that paper money in your hand. You gave it to them, now they have the rights. You don't have rights to that anymore. You can't go and use that. It's not yours because they have the rights. And but that's only one form of property that you can convey in these purchases. There's other instruments that can be conveyed, and by giving notices, these other instruments can be conveyed in certain ways, and if accepted by the other party, then they are obligated to perform on the assignment, if it was an assignment that it was conveyed by, with those rights. They have to use those rights as per the assignment. Going back, it says here, besides, a purchaser with notice has no right to complain when the third person of whose claims he had notice demands his own Besides, a purchaser with notice has no right to complain when the third person of whose claims he has notice demands his own. For the purchaser, under no compulsion to buy, and if he paid more than the vendor's interest in the property was worth, or if the third person's claim proved greater than he supposed when he bought, he deliberately assumes these risks and cannot in good reason and conscience be heard to complain. So I'm guessing this is saying that, if you buy something, even at a higher price than it was going for somewhere else, or at a higher price, you're buying it at a higher price, then later on, I guess if you see that it's selling cheaper somewhere else, well, you paid for it already. I'm guessing this is what that means. I'm going to find out a little bit more if we keep on reading. Any loss resulting from the prior or superior equities of the third party, the purchaser with notice must charge to his own negligence or willfulness. For when one of two persons must suffer a loss, he shall suffer whose own act or negligence occasions such loss. It would be manifestly contrary to reason and conscience to require the innocent third person to bear this loss. In conformity with these general doctrines, the rule is clearly established that a purchaser with notice of another's rights in or to the thing purchased is in equity. Yeah, because he's, again, this is by assignment. You see what it's saying is that in conformity with these general doctrines, the rule is clearly established that a purchaser, let's say someone's buying something with notice of another's right, meaning they're buying it for somebody else using their rights, right? Like a trustee, right? When you transfer something to a trustee to do certain thing, to purchase certain thing for you, right? Or to the thing purchased is in equity, yeah, because in equity it's all about trust. Then it says liable to the owner of those rights to the same extent and in the same manner as the person from whom he made the purchase. On the other hand, a person who acquires title to property in manner in which another has an equity and pays a valuable consideration for it without any notice of such equity may hold the property freed from that equity. Okay. On the other hand, a person who acquires title to property in which another has an equity and pays a valuable considerations for it without any notice of such equity may hold the property free from the equity. It's interesting. Let's see, it says footnote number 6. We'd have to research that. Okay. Notice defined. Notice is such information concerning a fact actually communicated to a party by an authorized person, or actually derived by a party from a proper source, or presumed by law to have been actually acquired by him, as is equivalent in its legal effects to full knowledge of such fact. Notice, therefore, is of two kinds. First, that actually communicated or derived, and second, that presumed by law to have been acquired. The former is called actual notice. The latter is called constructive notice. Actual notice includes all those instances in which positive personal information of a matter is directly communicated to the party, and this communication proved as a fact. Constructive notice includes all other kinds of notice, being those in which the information is conclusively presumed from certain facts, or is implied as a presumption of law in the absence of contrary proof. So this would be like getting a notice to appear at court as a defendant. Yeah, they're sending notice on the presumption that you are a defendant. You're a debtor or something like that. So it's a presumption of law, which happens in court a lot. There is no difference in their consequences between actual and constructive notice. Sheesh. Notice to an agent when notice to his principal. Notice to an agent in the business or employment which he is carrying on for his principal is a constructive notice to the principal himself, so far as the latter's rights and liabilities are not involved in or affected by the transaction. This rule alike includes and applies to the positive information and or knowledge obtained or possessed by the agent in the transaction, and to actual or constructive notice communicated to him therein. The general rule that notice to the agent is notice to the principal will operate with equal force and effect, whether the notice to the agent be actual or constructive. Actual knowledge may be brought home to the agent by the most direct evidence, or he may be chargeable with constructive notice by Lis Pendens. I'm guessing they're going to say what this is, but let's look it up. What is this word right here? Let's see. Come here. There we go. Lis Pendens, an official notice to the public with a lawsuit involving a claim on a property that has been filed. Lis Pendens is connected to the concept that the property buyer must assume any litigation exercise. A Lis Pendens can only be filed if an action is pending. Additionally, the pending suit must involve real property such as land and buildings. If these requirements are not met, the notice, it's a notice of a suit. Notice by Lis Pendens, a suit by a registration, by recitals in title deeds, by possession of the property by a stranger, or by circumstances sufficient to put a prudent man upon inquiry. In all such cases, the effect upon the principal is the same as though the information or notice to the agent had been to him in person. So, notice to one partner is notice to the other as to partnership matters, but not as to individual matters. And notice to one or more directors is notice to the corporation. Damn. Notice to the... Wow, okay, that's interesting. I gotta start sending some notices to these directors, you know what I mean? 3. Effect of being put on inquiry. Whenever a party has information or knowledge of certain extraneous facts, which of themselves do not amount to, nor tend to show an actual notice, but which are sufficient to put a reasonably prudent man upon inquiry respecting a conflicting interest, a claim, or right, and the circumstances are such that the inquiry, if made and followed up with reasonable care and diligence, would lead to a discovery of truth, to a knowledge of the interest, knowledge of the claim or knowledge of the right which really exists. Then the party is absolutely charged with a constructive notice of such interest, claim, or right. The presumption of knowledge is then conclusive. Circumstances from which notice may be inferred. Among the facts and circumstances from which actual notice may be inferred are the following: close relationship, personal intimacy, or business connections existing between the purchaser and the party with whom he is dealing, or between him and the holder of an adverse claim. 2. Great inadequacy of price, which may arouse the purchaser's suspicion and put him upon inquiry as to the reasons for selling the property at least than its apparent value. At less than its apparent value. And 3. The sight or knowledge of visible material objects upon or connected with the subject matter, which may reasonably suggest the existence of some easement or other right belonging to a third person. Rules of Lis Pendens. During the pendency of a suit in equity, neither party to the litigation can so alienate or encumber the property in dispute as to affect the rights of his opponent. Alienate, I believe in law it means to separate title. This rule of Lis Pendens is based both on necessity and on notice. So there's a rule, it says here. The rule of Lis Pendens is based on both necessity and notice. You gotta give notice if you're gonna end up suing somebody, right? You can't just boom, lawsuit. No, you gotta give notices along the way. 1. It is based on necessity because it did not exist. Any litigation might be indefinitely prolonged in consequence of successive alienations of the property in dispute, making it necessary to be constantly bringing the successive alienees before the court. 2. It is also based on notice because the records of the court are notice to the world. Hear that? The records of the court are notice to the world. And it is mainly from this standpoint that the subject will be considered. It has to be on the records. The Lis Pendens and the consequent notice begin from the service of a subpoena or other process after the filing of a bill. For the court must have acquired jurisdiction of the defendant before he can be bound and continue through the entire pendency of the suit, and only when the suit is really ended by a final decree. In order, however, that a purchaser pendendelite may be thus affected, the suit must be prosecuted in good faith, with all reasonable diligence and without unnecessary delays. Quick, fast, and hurry. Lis Pendens is notice of everything averred in the pleadings pertinent to the issue or the relief sought. Let me read this again. Lis Pendens is notice to everything averred in the pleadings pertinent to the issue or to the relief sought, and of the contents of exhibits filed and proved. In order that the notice may thus operate, the specific property to which the suit relates must be pointed out in the pleadings in such a manner as to call the attention of all persons to the very thing, and thus warn them not to intermeddle. It is not necessary that the land should be described by metes and bounds. Certainly, to a common intent, reasonable certainty is sufficient. Why did he put that there? It is not necessary that the land should be described by metes and bounds. Certainly, to a common intent, reasonable certainty is sufficient. Okay. 67. Estoppel and their effects. Okay. Whenever A, by acts, words, or silence, intentionally causes or permits B to do a thing he would not otherwise have done, it would be manifestly inequitable for A, by repudiation, the very conduct by which he induced B to act, and by setting up rights of his own, inconsistent with his said conduct, to compel B to incur a loss, by undoing the very thing A's conduct caused him to do. Courts of equity will not permit such an inequitable action on A's part, and will not allow him to set up any claims inconsistent with those acts, words, or silence of his which induced B to do what he did. This doctrine of equity is termed estoppel, and when fully considered will be found to rest upon three maxims. 1. When one of two persons must suffer a loss, it must be borne by him whose conduct occasioned it. Oh man, I like this one. This is good. 2. No one can take advantage of his own wrong. So it's kind of like when okay, I get it. So let's say a public trustee delegates authority to one of his subordinates, and then that subordinate delegates authority to another subordinate, and then that subordinate stops you and tells you that you need to do such and such, and you're like, well, that's wrong, I don't want to be part of that, I think that's wrong, that's unlawful. I said, no, but I have the authority to tell you to do that. And you're like, no, but I don't want to do that, that's wrong. Why are you going to make me do it? Not even you're going to do that. And they try to enforce you to do something that you know by law you don't have to participate in. It's like entering into contracts and agreements that you know are not necessarily legal or lawful. So you put an estoppel to it. I get it. I see what they mean. Okay, this makes sense. He is not to be heard who alleges what is contrary to his former statements. It is also a principle of equity that every person is bound to make good those intentional representations whereby he induces another to act. It is sometimes said that equitable estoppels result from fraudulent conduct on the part of the persons estopped. While this statement is rather broad, it is nevertheless true that when B has acquired rights, or incurred liabilities, or parted with a consideration on the fate of A's conduct, it would be fraudulent in A to repudiate such former conduct, or to set up claims inconsistent with his former conduct to B's injury. Okay, so they is giving footnote here 16. It says here, on estoppels by conduct, see blah blah blah. Okay, I didn't say much right there. Let's read on where we are here. Okay, here. The word, what is that? Conduct? The hell is that word? Adam. I think this is conduct. When used in reference to a person's estop, means conduct in its broadest sense. Yeah, this is, I don't know why it looks like that. It looks like E-O-N-D-U. Anyway, it's conduct. See, even right here, they put an E instead of a C. In the broadest sense, and includes the words and silence. And includes words and silence, positive acts and negative omissions. What? Let me read it again. The word conduct, when used in reference to a person estopped, means conduct in its broadest sense, and includes words and silence. words and silence, positive acts and negative omissions. Okay. The general rule of estoppel in cases of lands is that if a person interested in an estate knowingly misleads another into dealing with the estate as if he were not interested, he will be postponed to the party misled. I don't even know what that means. And be compelled to make his representation specifically good. It applies to one who denies his own title or encumbrance when inquired of by another who is about to purchase the land, or to loan money upon its security. 2, to one who knowingly suffers another to deal with the land as though it were his own. 3, to one who knowingly suffers another to expend money in improvements without giving notice of his own claim, and the like. 19, let's see what 19 says. Is there anything here? Nah, it's nothing here, so I'll just, the only thing right here says right here, on 22 they're going to give something right here, see? Where are we? Okay, right here. But in all such cases, there must be intentional deceit or gross negligence equivalent to fraud. The tendency of the law is to give married women enlarged rights and dethrall them of many of the disabilities under which they formerly labored. With an extension of rights is coupled an extension of duties and liabilities. A married woman is not privileged to perpetuate frauds or to mislead people to their hurt. And she may be estopped by her words, silence, or conduct in the same manner and nearly to the same extent as though she was under no disability, especially when her conduct has been both fraudulent and very injurious to the other party. An infant may also be bound by an estoppel when it would operate as a fraud upon the other party to allow the infant to repudiate his conduct, fraud not being one of the privilege of infancy. Fraud not being one of the privilege of infancy. What does it say right here? So, an infant who obtains money from his trustee or guardian by fraudulently representing himself to be of age is estopped to recover this money when he attains his majority. So if he tries to, if a beneficiary tries to get money under fraud, then his 18th birthday comes, they're going to stop him. They're like, no, you've messed up already. We don't trust you anymore. Okay, I guess that's what they're saying. The measure of the operation of an estoppel is an extent of the representation made by one party and acted on by the other. The estoppel is commensurate with the thing represented and operates to put the party entitled to its benefit in the same position as if the thing represented were true. With respect to the person who are bound by or who may claim the benefit of, the estoppel, it operates between the immediate parties and their privies, whether by blood, by estate, or by contract. What does it say here? Okay. 68. Acquiescence and its effects. Okay. A party who has a right of action may lose that right either by a confirmation of his voidable transaction or by acquiescence in the transaction, or by mere delay or laches in bringing suit. Laches in bringing suit. What does laches mean? Laches. Let's see what laches is. Hold on. Legal. Okay. Legal. A doctrine of laches is a legal defense that may be claimed in civil matters, which asserts that there has been an unreasonable delay in pursuing the claim, filing the lawsuit, which has prejudiced the defendant or prevents him from putting on a defense. It says here, in common law legal system, laches is a lack of diligence and activity in making a legal claim or moving forward with legal enforcement of a right, particularly in regard to equity. Okay. Laches is an equitable defense that bars the plaintiff from pursuing a claim that has been delayed for an unreasonable amount of time, causing prejudice to the defendant. Oh, so if they keep postponing and postponing and postponing, that's like the defense will be, hey man, what's up with all these laches, man? Learn the difference between laches and statutes of limitation of how to assert laches as a defense, and see real life example. Wow, okay, it's interesting. Okay, so by mere delay or laches in bringing suit, if a party with full knowledge of the facts and of his rights freely and deliberately ratify a voidable transaction, such as an act forever terminates any right he may ever have had to question the transaction thus ratified and confirmed. So, if a party with like knowledge of the facts and of his right freely and deliberately acquiesces in a voidable transaction and take or claim benefits under it, he will be estopped to question the validity of such transaction. Mere delay, mere suffering, time to elapse without doing anything, is not acquiescence, although it may be, and often is, strong evidence of an acquiescence, and it may be, and often is, a ground for refusing equitable relief. In order to constitute acquiescence, there must be 1. Some act which, though not deliberately intended as a ratification or confirmation of the voidable transaction, nevertheless recognizes it as existing and claims or obtains some benefit resulting from it. And 2, this act must be done with knowledge of the material facts and of the actor's rights under those facts. And 3, without any undue influence or restraint. Rights, once valid, are often lost by delay and the implied acquiescence resulting from such delays. Acquiescence consists of mere silence, may also operate as a true estoppel in equity, to preclude a party from asserting legal title and rights of property, real or personal, or rights of contract. The requisites of such estoppel have been described. A fraudulent intention to deceive or mislead is not essential. All instances of this class in equity rest upon the principle: if one maintains silence when in conscience he ought to speak, equity will debar him from speaking when in conscience he ought to remain silent. This principle includes all cases where an owner of property stands by and knowingly and without interposing any objections permits another person to deal with the property as though it was their own, or as though he were rightfully dealing with it, as by expending money upon it, making improvements, erecting buildings, and the like. Oh, okay, so you see, saying that if you own a piece of land and then you see somebody building in there and you don't, you know what I mean, like, you don't do anything, you don't say anything, you let them build the entire thing, and then you want to come and say, hey, well, Thank you. Wait a minute. What you mean, thank you? This is mine. All this is mine. He said, no. This is, I have rights. He says, well, you didn't say anything. You didn't say anything when I started this project a year ago. Yeah, okay, I get it. This makes sense. Okay, that was just an example. Of course, I'm back right here. Of course, it is essential that the person in possession should be acting in ignorance of the real condition of the title, and in the supposition that he was rightful in his dealings with the property. Parties who have long acquiesced in settlements of accounts or of other mutual dealings will not be permitted to reopen them, and this is true even though the parties stood in confidential relation towards each other, as trustee and cestake trust, meaning beneficiary, principal and agents, and the like, and the settlement embraced matters growing out of such relations. So, corporations may be stopped by acquiescence, like natural persons, either in their dealings with third person or with their own stockholders, and conversely, stockholders may, by acquiescence, be stopped from objecting to the acts of the corporation. If a mortgagor, obligor, or a other debtor, that's interesting because right here he's saying a mortgagor is a debtor, an obligor is a debtor, and any other debtor. So, you can tell that these are debtors. Okay, interesting. If a mortgagor, obligor, or any other debtor, by keeping silence under circumstances when he ought to speak, leads the intended assignee to believe that there is no defense, he will be stopped from afterwards setting up any defense which might otherwise be available as against the assignee who has thus been induced to purchase the demand. So this could probably fall under also when you sign a promissory note by just like a blank endorsement. You just sign it. You didn't claim a right. You didn't say, hey, without recourse, by such and such authorized representative of the principal, and flip that paper around and said, hey, for value received I hereby assign this instrument for the benefit of the principal by the authorized representative. So that's an assignment. Then one can make a claim on that later on, because the note has it on the record. That's the original, right? Has it on the record that note was assigned. It wasn't abandoned. You understand what I'm saying? So they can say, hey, you just signed general blank endorsement, so you didn't make any claim, so we took it and we sold it. It's ours. So when we try to make a claim afterward, they're like, nah, you messed up, man. You gave that up. So I could see why they don't respond to any of our claims when we try to do these counterclaims on these notes. But again, we'll probably read more on that later on here, how to fix that. Going back to this, in all these cases, the courts enforce the maxim: equity aids the vigilant, not those who sleep upon their rights. The neglect to do a thing in proper season is called laches. Oh, that's what it means, and that's what they're saying right here. The neglect to do certain things in proper season is called laches, and is one of the unpardonable sins in the sight of the court of equity. Sheesh, it's a sin. Damn. Look at this. This is talking about 24. Where is it? I can't find it. It's 26, 25. There is to us right here. A confirmation of voidable transaction, because it says here, Whenever any contract or conveyance is void, either by a positive law or upon principles of public policy, it is deemed incapable of confirmation, it being a maxim. But where it is merely voidable or turns upon circumstances of undue advantages, surprise, or imposition, there, if it is deliberately and upon full examination confirmed by the parties, it will be valid. Okay. 69. Negligence and its effects. It has often been said that, in general, nothing can force a court of equity into activity but conscience, good faith, and reasonable diligence. Equity aids the vigilant, not those who slumber on their rights. Laches, delay, indifference, and passive acquiescence, when not in any way caused by the other party, are hurtful, if not fatal, to the complainant's rights in the court of equity. The doctrine that equity requires good works as well as good faith is especially enforced against trustees. Listen to who? Trustees. Public trustees who volunteer by their oaths. I don't know why that comes to mind, but that always comes to my mind. Anyway, going back. Trustees and all other persons who act in the capacity of trust for others, especially in a fiduciary capacity, such as as executors, administrators, guardians, agents, receivers, clerks of court, and of individuals, secretaries, treasurers, and other officers of firms, societies and corporations, bookkeepers, guardians, ad litem, next friends, attorneys, and confidential advisors. Did this just associate the word individual and courts and of individuals, secretaries, treasurers, and other officers of firms? So you're saying that these is it kind of defining individual in a sense right here as being synonymous to all these different things right here. Any of these persons, when acting for others in reference to matter of property or business entrusted to their care and management, is to that extent a trustee and subject to all the obligations imposed by the courts of equity on trustees, and held chargeable for all losses resulting from their want of due diligence, equally with losses resulting from downright bad faith. The compensation ordinarily allowed trustees will be reduced or entirely disallowed in case of loss resulting from their negligence. Of persons acting as trustees, equity requires good works as well as good faith. Equity never interferes in behalf of a property whose negligence or delay has caused, occasioned, or contributed to the injury of which he complains. No one can take advantage of his own wrong. Oh, so alright, I got you. I see what I'm saying. Okay. So if you are negligent in your affairs and because of that you suffer a loss, but you want to take advantage of that loss, equity won't back that up. That's what it's saying. So no one can take advantage of his own wrong, and we're back right here. And when one of two persons must suffer a loss, that one shall suffer it whose act or negligence occasioned it. The one who did the wrong is supposed to suffer the loss. Clean hands, a pure heart, and a swift feet are required of him who seeks the aid of the court of conscience. And if, in any case, it appears that the inquiry complained of might not have happened had the complainant or his agents or attorneys been duly diligent. The court will stay at its hand and decline to interfere. This doctrine runs all through both the practice and the jurisprudence of the court. The court will not relieve against negligence in pleadings, or in taking any steps in court, or in taking proof, unless upon the payment of compensatory costs. So, the courts will not relieve against a forfeiture, or an accident, or a mistake that is the result of negligence. Equity will not relieve against a judgment at law, nor rehear nor review one of its own decrees. When the wrong complaint of could have been prevented, or the new evidence brought forward could have been obtained by reasonable diligence at or before the former trial. Nor can he who is put upon inquiry escape the consequences thereof by declining to make a proper investigation. In equity, every man is chargeable with all that due diligence in the particular matter would have been resulted in. Equity requires a party to do all that in a good reason and good conscience he should have done, and a failure to do what was a party's duty to have done will not relieve him from the penalties of his negligence. Besides negligence in acting when one's rights have been invaded may be deemed evidence of an acquiescence, or may become laches, and thus bar a party from asserting what would, on due diligence, have been a clear right of action. 70. Laches and its effects. The neglect of a person to make complaint or bring suit in due season, he being sui juris and knowing the facts or having the means of knowledge, is called laches. And where there has been gross laches in prosecution rights, or long and reasonable acquiescence in adverse rights, courts of equity refuse to interfere, they acting either by analogy to the statutes of limitations or upon their own inherent doctrine of discouraging inadequate demands. The court realizes the difficulty of doing entire justice when the original transaction has become obscured by time and the evidence lost, and deems it good public policy to allow claims and titles long acquiesced in to remain in repose. Nevertheless, when there are circumstances excusing or justifying the delay, courts of equity will not refuse their aid. Yeah, because if you genuinely didn't know, and you just found out about this, man, you know what I mean? Just found out that when you give them a promissory note, they can use that as a form of asset, which will extend credit to them, and then the other party that is purchasing those promissory notes in the form of bonds or securities, or acquiring them in the form of securities, and later they make some money and profit out of it. You know what I mean? If you didn't know anything about that, how would you know that you can make a claim to those instruments? You wouldn't know. But if you come to find out, then I believe that's when the notice comes in. Hey, I just found out about this, man. I had no idea. I didn't know I could make a claim to this. Nobody ever told me, and I just found out. And now that I found out, I wish to apologize for not bringing this earlier, but I just didn't. I can't. It's impossible for me to bring it without knowing any of this. No, if unless there's evidence, clear evidence that I was told this, and I ignored it, then please show it to me. Unless that, then I didn't know it. So I'm making my claims to that promissory note, to that security, and so on and so forth. So that's why I think it's important that we transfer that right to another party, like a trust. So once that trust acquires it, that trust can make the move and say, hey, I know there's rights attached to this. I know he probably slept on his rights, but I'm not sleeping on those rights. I'm making my claim. So I think that's why it's good to transfer these over to a different entity and then have that entity make those claims on our behalf. It has been said that, I'm reading now right here, it has been said that nothing can call a court of equity into activity but conscience, good faith, and reasonable diligence. The court never lends its aid to one who, with knowledge of his rights and with opportunity to assert them, delays unreasonably so to do. Equity aids those who are vigilant, not those who sleep upon their rights, and always discourages stale demands. Time and equity is a witness that what has long been acquiesced in must originally have been founded in some right. In this respect, it is wholly independent of the statute of limitations. The court frowns upon attempts to unsettle what has long been at rest because of the difficulty, if not impossibility, of making proof. Second, because in uprooting an ancient matter, innocent persons are liable to be injured. That's true. Third, because the defendant, even if originally in the wrong, may, as a result of the complainant Laches, have acquired such affirmative rights that he cannot be placed in statu quo. And fourth, because the delay raises a presumption that originally there was, if not a good defense, at least a better one that can now be made. If a party have knowledge of his rights, his delay will not be excused because of property or want of evidence. If a party have knowledge of his rights, his delay will not be excused because of property or want of evidence. Okay? Laches will bar suits. 1. To open accounts and settlements long acquiesced in. 2. To change a boundary line long recognized. 3. To correct an alleged fraud, incident, or mistake long submitted to. 4. To have a nuisance abated that has long existed. 5. To have a contract either rescinded or specifically enforced, when by delay the parties cannot be placed in statu quo. 42. 6. Or to have any transaction uprooted or any business unraveled, when in conscience of long acquiescence the chances are that material evidence has been lost, that the memory of the facts has become dimmed, that parties or witnesses have died or removed, and that new rights have sprung up and should not be unsettled. But no delay would prejudice a defrauded party as long as he was ignorant of the fraud. See, there you go. That's what we're talking about. And especially if the defendant concealed the facts, which it was his duty to disclose, or deceived the complainant by misstatements, or otherwise lulled his suspicion. The sleep of the complainant cannot be used as a defense by him who caused that sleep, for that would be to take advantage of his own wrong. Man, these people are deep. Okay, so that's it for right now. That one's that. We're in waivers. So I'm going to stop here. And again, let me show you. This is... let me show you. Here we go. A treatise on suits in chancery, setting forth the principles, pleading practices, proof, and processes of the jurisprudence of equity, and giving numerous illustrative forms of pleadings, writs, orders, reports, decrees, and other proceedings in suits in chancery from their beginning and their end. Besides, many practical suggestions for solicitors and masters. Cursus curia etes, curia. Henry Gibson, that's the guy. The author. That's all for now. Peace, love, and law.